Hi everyone. So we will start our webinar for today. So so first of all, let's just start. So hi everyone. Good evening. Very warm welcome to you from Dilzer Consultants, a SEBI registered investment advisory firm. Today we are conducting a webinar on estate planning and will creation from our monthly webinar series. Today in this webinar, we have our expert, Mr. Suresh A, a qualified paralegal and state planner from PropSeva, who will be presenting and informing us on the importance of state planning and will creation. After that, we will have a small Q&A session where he will be answering the questions and sharing their knowledge with all the participants. Hi, I am Chetan Joshi, a certified financial planner with Dilza Consultants. Our agenda for today is to broadly cover the importance of wealth creation and state planning and to provide the best suggestion that will benefit our participants to help them to achieve financial freedom and reducing their overall financial risk. This is an initiative to create financial awareness to all the peoples related to Dilzer Consultants. The goal is to provide the value around investments, saving, insurance, loan, and other financial planning activities. Now, let me properly introduce our guest, Mr. Suresh A. Mr. Suresh is a qualified paralegal and state planner. He is adept in the matter connected with inheritance, succession laws, and business succession plans. He is one of the promoter and executive director of PropSeva and comes on board with 30 years of experience, of which the last 20 years is in financial service sector. He has got hands-on exposure to various personal finance facets such as estate planning, succession planning, investments, insurance, tax planning, and real estate. Before moving on, I would like to share a little about Dilzer Consultants Private Limited. Dilzer Consultants is a SEBI registered investment advisory company. Our advisory practice is built on the foundation of trust, integrity, and responsibility, and hence we are always committed to the exceeding the expectations of our clients. We offer a progressive financial planning practice that differentiates itself by being disciplined, well researched, and profitable. We have over 22 years of experience in financial service advisory domain. With over 300 families, we have created financial peace and independence in many people's life and help them realize the financial goal. Lastly, we request you to follow us on social media platforms if you haven't yet. We share daily news and updates regarding finance and the other things there. So, thanks for joining us. Now, over to Mr. Suresh.
Thank you, Chetan, for your introduction and nice words. Good evening to all the participants and a warm welcome to you all to this webinar on estate planning. Right. Hope you are not able to see my screen.
Yes, sir, it's visible.
So good evening, everyone, and thank you for joining this webinar on estate planning. I'm sure the next 1 hour will be of great awareness for you to safeguard and protect the financial security and future of your family members. And the question comes about what is estate planning? So estate planning is all about inheritance of one's assets. So estate, people think that it's something about real estate or some other coffee estate or something. So when you talk about estate here, it deals with all your assets, all assets owned by a person. So it is planning is nothing but for the inheritance of such assets. Why this topic needs to be discussed? Why it is important to know about estate planning? Now consider this: more than 1 lakh crore of funds or amount are lying with the financial institutions in India like banks, mutual funds, depository accounts, provident fund accounts, and other financial assets. Please underline this point: 1 lakh crore is lying unclaimed. When I say lying unclaimed, no claim is made for last 10 years. A deposit or investment will be considered as unclaimed when no claim is made for 10 years or more. And still there are many in pipeline which is yet to complete 10 years. You would have come across recently in the news around 35,000 crores of amount is transferred by only public sector banks to Reserve Bank of India in the month of February 2023, which are unclaimed for over 10 years. 35,000 crores only from public sector banks. And imagine now what could be the amount with the other banks, insurance companies, AMCs and mutual fund companies, and any other financial institutions. On the other hand, if you look at the civil courts, more than 60% of the cases filed in the civil courts are related to the inheritance disputes or property disputes. So what can we do to avoid such scenario? What can we do to ensure that your amount also does not go to the pool of 1 lakh crore, or your property also does not go into the disputes and to be settled in the court? The answer is estate planning. Had these people whose money is not claimed or wherever they dispute about the property, had they had the estate planning, most of the cases this scenario could have been avoided. The families would have got the access to these funds comfortably without any complexities. So today we make an attempt to bring you awareness. If a person dies, what happens to his assets, who will have a right to inherit, and how do they inherit, what are the options we have to make it seamless to the family members. So estate planning is for the people or for the persons whom you care about and for the people who care about you. So if you love your family and other members, one way to show them your love and affection to them is to have an estate plan and provide them that kind of security in your absence. So with this, let us just go deep into the estate planning. So we all own various kinds of assets. Could be in the form of property or shares, bonds, debentures, jewelry, mutual funds, car. All these assets are owned by a person or persons. An asset cannot remain without ownership. Otherwise, anyone can make a claim over it. So when you own a property, you say that I am the owner because there is a registered deed in your favor. It could be sale deed, partition deed, gift deed, whatever it is. There is a registered document in your favor by which you claim that you are the owner of the property. You have a bank account, there is a statement in your name, who is account holder. You are invested in mutual funds, there is an account statement identifying the account holder or investor. You have a bonds and debenture shares, the name of the owner is identified. A car registration certificate will have a name of the owner. So every asset is connected with a person or persons who is considered as an owner. So what? So this owner has a right to have a control over the property, right to manage the property, right to use or distribute the benefits of the property, and right to deal with this property. This is what is the benefits attached with the ownership. Okay. So one day we all have to leave this world. Let us accept death. Death is also a part of life. And one day it comes to us. We all are in the queue. Someone is ahead, someone is behind. But definitely our turn will come. So when such day happens or when such day comes, now the question arises, whatever assets owned by you, who will own it and how do they own it? So this remains a big mystery for many people. And because of this, there are complexities and disputes. So in this webinar, we go into the deep to understand when a person dies, who will have a right to own his assets or inherit his assets and how do they own it. Of course, when a person dies, when the assets pass on to the legal heads or family members, we call it as an inheritance. The question comes, who will decide about inheritance? You as a owner of the asset, you have every right to decide who will own your assets after your life. But if you don't decide, then law will decide. So there are only two options. Either you decide or leave the law to decide. So when you decide and have a plan for the inheritance of your asset, we call estate planning, or also we call it testament. When you don't have any plan for the inheritance of your asset and the person leaves this world, he dies, then we call intestate. So since here the person has not decided, he died intestate, the law will take over and law will determine who are all the legal heirs of the person and what rights they have on the inheritance of the deceased person's property. If you have to choose between these two options, what could be your option? Whether you would like to have a testament or intestate. I'm sure your answer would be testament. But unfortunately, many doesn't have any plan for their inheritance. That means they have left it to the law to decide. Could be ignorant or could be carelessness or not interested. So here, the default option is intestate. If you don't have a plan, default option is intestate. This box is already checked. So if you have to uncheck this intestate box, then you have to check the box of testament. That means you need to have a testamentary document or estate plan. So since the default option is intestate, in such case, the law will decide the rights of inheritance. We'll just go into the deep what the law says about the inheritance of the assets of the person who died intestate. So we have different personal laws in India, which are known as succession laws. So these laws are Hindu Succession Act 1956, Indian Succession Act 1925, and Muslim Personal Law. This Hindu Succession Act 1956 applies to the inheritance of the assets left behind by a Hindu, Buddhist, Sikh, and Jains. When we say Hindu wherever, it includes Buddhists, Sikhs, and Jains also. And this Hindu Succession Act determines the legal heirs of the Hindu and also the share of each person in the inheritance of assets. Whereas Indian Succession Act 1945 had made a provision to determine the inheritance of the assets left behind by the Indian Christians and also of those couple whose marriage is solemnized under the Special Marriages Act. That means where the marriage between the two persons have taken who belong to different religions, like Hindu, Christian, Christian, Muslim, Muslim, Hindu. In such case, again, Indian Succession Act 1925 applies. And in case of Muslims, it is Muslim Personal Law. So here itself, if you see, the law that is applies to Hindus does not apply to Christians. The law that applies to Hindus does not apply to the couple who belong to different religion. So here itself, certain complexities are arise. Now let us go into each of these succession laws in detail. So first we will take a Hindu Succession Act. Again, has made a provision separately for male and Hindu female. That means the rules for succession of a Hindu male dying intestate is different for the rules of Hindu female dying intestate. So first let us see what the Succession Act, Hindu Succession Act says when the Hindu male dies intestate. The legal heirs of Hindu male are classified into three categories: Class 1, Class 2, and residual. So as per the Hindu Succession Act, the first rights of inheritance will go to Class 1 legal heirs. In the absence of any Class 1 legal heirs, the rights will pass on to Class 2 legal heirs. If there are no Class 1 and Class 2 legal heirs, then it will pass on to residual, means who are not into the Class 1 and Class 2 other relatives. It very rarely goes to residual, so mostly it goes to Class 1 and certain cases in Class 2. So many are not aware who are all the Class 1 legal heirs. When I ask many of the clients, okay, do you know if you are not around, who will inherit your property? Someone say my wife only, someone will say my wife and children, someone will say my family, without defining who all consists the family. So today, now we will know who are all the Class 1 legal heirs of Hindu male. The Class 1 legal heirs of Hindu male includes his mother, wife, and children. When I say children, both son and daughter. Equal rights. So when a Hindu male dies intestate, that is without any estate planning or planning for inheritance, so Hindu Succession Act will apply. As per the Hindu Succession Act, Class 1 legal heirs have a first rights of inheritance, and Class 1 legal heirs include mother, wife, son, and daughters. Equal rights, all have equal rights. So in this case, assuming that a Hindu male died leaving behind his parents, both mother and father, wife, a son, and daughter. So father is not a Class 1 legal heir. Father does not have a rights of inheritance. It is only between mother, wife, son, and daughter. 4 Class 1 legal heirs. Each of them will take 1/4 of the property of the deceased Hindu male. So here, the distribution of the asset may not happen as per the wishes or the requirements of the family. Say for example, my mother or my son and daughter are not financially dependent on me, whereas my wife is dependent on me. Then how do I provide that financial security to her in my absence when I am no more? The only option is to have a testamentary document. If you don't have a testamentary document, if I don't have a planning for inheritance, then even my mother, son, and daughter can make a claim. and money is the biggest corrupter of mind. There could be claims from other family members. So, in what way I'm giving security to my mom? Or if you have other scenario, my parents are financially dependent on me, whereas my wife and children are not dependent on me. I'm concerned tomorrow if I'm not around, who will take care of my parents? So unless I have a succession plan for them, they are left to the mercy of the other family members. So every family has certain people who have certain needs. There is a need to give some financial protection to them. Or there could be a family member who is special person, disabled, who needs some financial support, additional financial support. So how do we provide this? By executing an estate. So these are the class 1 legal heirs of Hindu. In case if any son or daughter has predeceased and they have left their family behind, so the share of a predeceased son will go to his legal heirs, to his branch of legal heirs. Similarly, the share of a predeceased daughter will go to her children, son and daughter. So this is what is about the class 1 legal heirs or rights of inheritance. That's what I made a point here. So in the absence of any class 1 legal heir, then the rights will pass on to class 2 legal heirs. There are many relatives are specified in class 2 legal heirs in different orders of succession. All these relatives will not have an equal right. It is only the order of succession. The first in the order is father of a Hindu male who died intestate. So if there are no class 1 legal heirs, then father will have a first right among the class 2. Even if father is not alive, then it will go to brothers and sisters and sons, daughters, son. So when there are different relatives in the same group, all take together equally. So in the second column, we have in the absence of father, the rights will pass on to brothers, sisters, sons, daughters, son. There are 3 relatives here, 3 legal heirs here. All 3 will share equally. Even if none of the relatives in second block are not alive or available, then it will go to daughter, son, son. Then it goes to children of brothers and sisters and so on. So here people are not aware about this law. Everyone have their own assumptions about the rights on the property of a deceased person. They make a claim, each one will make a claim without understanding their rights. This is where the dispute arises and go to the court. But law is very clear. Who has the rights of inheritance? This law is made in 1956. It's not something new. To say, I don't know about it. But lack of awareness. Even if none of these class 2 legal heirs are not there, then it will go to residual. Let's not go much, it's too much to go to that level. So what is about the inheritance of the assets of Hindu male and Hindu female? So next we will go to the succession of Hindu female. So when it comes to the succession of Hindu female, so we have to look at the source of acquisition of assets by Hindu female. How the Hindu female has acquired these assets. Broadly, we can classify into 3 categories. The assets held by Hindu female could be self-acquired assets, or she could have inherited from parents, or it is inheritance from husband or father-in-law. In each of these cases, the rights of inheritance will be different. It's not that all the assets of Hindu female will go in the similar fashion or inherited by the same legal heirs. It all depends upon how these assets are acquired. So first we'll go to self-acquired assets of Hindu female. If she dies intestate, the rights will first pass on to the husband and children. Any self-acquired asset, either before or after marriage, the rights will pass on to husband and children. If husband and children are not there, in the absence of them, then it will go to the legal heirs of the husband. It will be treated as if it is a property of the husband. It will go to his legal heirs. If there are no legal heirs of the husband, then it will go to the parents of the Hindu female. They are in the 3rd category. Even if parents are not available, then it will go to the legal heirs of the father and finally legal heirs of the mother. Very rarely it goes to that extent. So most of the times, in the absence of husband or children, it will go to the legal heirs of the husband. That means Hindu female property will go to his mother-in-law, to her mother-in-law, in her absence father-in-law, in her absence brothers and sisters of husband. If any Hindu female don't want this to happen, then make an estate. So these are about the self-acquired assets of Hindu female. And next we have inheritance from the parents. So a Hindu male died, leaving behind son and daughter. So daughter also has rights of inheritance. So daughter got the property, it becomes inheritance from the parents. So any property inherited by a Hindu female from her parents, upon her demise without any estate planning, will pass on to sons and daughters. Not to the husband, it is only to sons and daughters. Even though husband is alive, if there are no sons and daughters, husband will not have any right. The property will revert back to the legal heads of the father or legal heads of the mother in such case, from whomsoever she has inherited. So, one point to be underlined here is that husband of a Hindu female will not have a rights on the property of the Hindu female which she got by way of inheritance from her parents. It is only children. In the absence of children, it will go back to the legal heirs of the father or mother. Another point is where the Hindu female has inherited property from husband or father-in-law. So if it has inherited from husband, of course it goes to sons and daughters. Okay. If it is from father-in-law, legal heirs of the. In the absence of sons and daughters, it will go to legal heirs of the husband. So these are the three scenarios we have to look into it when a Hindu female dies intestate. The first question to be asked is, or to be looked into is, what is the source of acquisition? Then we can determine the legal heirs of Hindu female. Again, many are not aware about these rules. Everybody thinks that husband has a right, children has a right, or someone has a right, and this is where the disagreement arises and disputes. Right. So this is what in brief about rules of inheritance for the property of Hindu female and Hindu female who die intestate. So next we'll move to the Indian Succession Act. So Indian Succession Act is different from Hindu Succession Act. It does not make any separate provisions for the assets of male and female. The rules of inheritance is same whether it is a male or female who died intestate. So let us take different scenarios here. An Indian Christian, could be male or female, died intestate without any planning for inheritance. In such case, if he or she has left behind husband or wife, case may be, and also the children, only 1/3 will go to the surviving spouse, remaining 2/3 put to the children. Only 1/3 to the spouse, 2/3 to the children. If I were to be Indian Christian, I die intestate, 1/3 of my property will go to my spouse, and remaining 2/3 my children will have it. My wife is Indian Christian. If she dies, 1/3 I will have a rights of inheritance, and 2/3 of her property will go to my children. Indian Christian leaving behind widow, no children, but other relatives. Kindred means close relatives. Even in such case, only half of the property will go to the widow, and remaining half to the close relatives. The close relatives are kindred. First is father, then mother, brothers and sisters. So if I were to be Indian Christian, married, no children, if I die intestate, 50% of my property will go to my wife, 50% will go to my father. If my father is not alive, the remaining 50% will go to my brothers and sisters. My mother, brothers and sisters. If Indian Christian has left only widow, no other relatives, close relatives, then whole of the property will go to the widow. Not married, no descendants, no children, then it will go to the father. In the absence of father, mother, brothers and sisters. So if you see here, each of the scenario, the rules of inheritance is different. A common man might not be aware about all these rules. So they are confused. Who has the rights of inheritance, how much right they have. And everyone will have their own assumptions, leads to disputes. For Parsis, it is again little different. If a Parsi has left behind widow and children, they take one share each. Only children without widow, then each of the child will take one share each. If Parsi has left behind widow, children and parents also, then widow and children take one share each, and parents take half a share each. That means both parents together will take one share. So these are the succession rules for the Parsis. And then next we have Muslim laws of succession. So Muslim laws of succession derives its various rules from Quran, the practice of Prophet, what we call Sunnah, and the consensus of Muslim scholars, which is known as Isma, and good principles laid down by God, what we call Qiha. So the rules for the succession of Muslim property is that the first charge on the property of Muslim upon his demise will be to meet his funeral expenses. That will be the first charge. After meeting the funeral expenses, then all his debt has to be repaid out of his estate, clearing of debts, including mahr of wife. Mahr is a promise made by the husband to wife at the time of marriage to make a gift. If still it is due, then that is also taken as a debt. After meeting funeral expenses and debts, then whatever property is available can be bequeathed by Indian Muslim by way of succession laws. Otherwise, Muslim law will decide the rights of each legal heir. But here it is not so straight like Hindu law and Indian Succession Act. The share of each legal heir depends upon the number of legal heirs are left behind by the Muslim. It becomes much more complex. So ultimately, the legal heirs of Muslims are into two categories. One is sharers, other is residuaries. Sharers are those legal heirs who are entitled to a particular share of inheritance. Whatever is left behind after shared by the sharers, the balance will go to the residuaries. They succeed to the residual assets after claims of the sharers. Every sharer will have a certain percentage. So whatever is left after distributed to the sharers, then balance will go to the residuaries. So these are the laws we have for the succession of the assets of a person who died intestate. So far we've discussed it. Who will have a rights of inheritance? Then the next question comes, how the legal heirs can make a claim of the estate of the deceased person. When a person dies, how do legal heirs can make a claim? So one of the most widely used option here is nomination. So nomination can be made on financial assets. So nomination is nothing but appointing a person by the account holder or an investor on his assets and directing the banks and other institutions to pay the money to the nominee in the event of his death. So many think that nomination will transfer the rights to the nominee, but it is not so. When account holder dies or investor dies, as per the nomination, when the banks or other institutions pay money to the nominee does not have an absolute right on this money. This money belongs to legal heirs. Nominee is only a hand that is identified to receive the money on behalf of legal heirs. Nominee is only a custodian to hold the money on behalf of legal heirs. So nominee is required to distribute the money as per the provisions made in the will, if it is made, or as per the succession laws, what we discussed. Wherever is the legal heir rights of inheritance as per the succession laws. So nominee can be one of the legal heir, then he can take his share. But nominee does not have an absolute right on this. In the absence of nomination and the balance in the account exceeds certain amount, let us say 5 lakh rupees or more, then banks and other institutions may ask the claimant to produce succession certificate. A succession certificate is issued by the district court, and the certificate is issued only to make a claim on financial assets. And this is very time-consuming process and little expenses involved with it. The general experience is that it will take around 10 months to 1 year to get succession certificate. The claimants have to visit the court multiple times, 4 or 5 times. There could be expenses of upwards 1 lakh and above. But it does not apply to other than financial assets. So for other assets, we may have to get a legal heir certificate or a family tree, which is issued by the revenue department, like Tahsildar's office. In certain cases, we need a letter of administration. So these are the various documents that are required to make a claim on the assets left behind by the deceased person. And you have to run around to get all this documentation. Estate planning supersedes all this documentation, and this one document is enough to make a claim on all these financial assets and other assets. So ultimately, when a person dies without any estate planning, that is intestate, it results into complexities because people are not aware to whom to approach, what is the next course of action to take to make a claim on these assets. Legal heirs are uncertain how much money they get. Additional expenses are involved. The distribution of assets will be out of control, not as per the desires and needs of the family members. And there's a confusion among the family members. What to do, whom to approach. And of course, in many cases, there could be disputes also. So these are all the drawbacks, negativities of intestate. So how to overcome these? To have an estate plan. You decide. So when you decide, then you decide that you have executed a testamentary document or an estate plan. So what is this estate plan? So estate planning is a systematic approach to deal with the management of property and transfer of legacy to the next generation. Two things here: to deal with the management of your property during your life in the event of any incapacity, and transfer of legacy to the next generation. The primary objective of estate planning is to ensure smooth transfer of assets or estate to legal heirs. So estate plan avoids disputes among the legal heirs in the inheritance. It deters complexities and associated costs in inheritance. Moreover, it provides assets to the right beneficiary. Your hard-earned assets will go to the right beneficiary. And it reduces complexities among the family. So this is the primary purpose of estate plan. This is where I said, if you care for your family members, you care for their future security, then have an estate. Now the question is, whether do you need estate? Who needs estate plan? I have listed various situations here. If there is a tick mark for any one of the statement here with reference to your situation, then you need estate plan. That means you need an estate plan if you own a real estate, a movable property, a house property, a land. You need an estate plan if you're a single parent with minor child or children. You need an estate plan if there are financially dependent spouse or parents or siblings or children. You need an estate plan if any of the family member is suffering from critical illness and you would like to support. You need an estate plan if your spouse is incapable of managing the asset or the family members are spendthrift. A couple with no children need estate plan. In the absence of both of them, then the question arises, who will inherit their property? A family member with specific needs, any disabled member. So these are the various situations where a person needs estate plan. So what are the options we have in estate plan? 3 documents we use. One is will, second one is family trust, and third one is power of attorney. A will enables transfer of property or legacy to the next generation or family members. Whereas a trust protects your property for the benefit of family members and provide income only to the family members. And power of attorney will help you to reach where you cannot. That means where a person is incapacitated or not capable of managing, then he can authorize another person to manage his estate on behalf of him or her. So let us discuss in detail about will. So what is this will? A will is a written document by which you direct how your assets needs to be distributed upon your demise. So after the demise of a person, provision is made how his assets needs to be distributed amongst his legal heirs or any other person or persons. A will comes into force only after the demise of the person who made it, known as testator. So what kind of property that can be bequeathed or can be transferred or left as a legacy in the will? The property can be any kind of property. It could be financial assets like bank deposits, mutual funds, shares, and so on. It could be movable property like house property, land, building. It could be household assets like furniture, fixtures. It could be even tangible and intangible assets. If you own a business, proprietorship like goodwill and all. So any property which is capable of transferring to another person can be bequeathed by you. So important point to note here is that when a will is made, it is not final. The property or asset does not pass on to the legal heirs immediately. Okay, a will come into force only upon the demise of the person who made a will. So because of this, a will can be modified any time during the life of the testator. A will can be revoked or cancelled any time by the testator who made the will. So often one question is asked by many people, is it necessary to register the will? As per the law, registration of will is optional, but it is recommended to register the will. Especially if you own the immovable property, it is recommended to register the will. But law makes it optional. So whenever options are given, normally we will have to choose we'll take the wise decision, whichever is good for us. Option is given, whichever is good for us, we take the decision. We will not decide or choose such option which is not favorable to us. So when will is registered, this option is favorable to you when it comes to the implementation. Right? So though it is optional, think of registering the will when you are executing. So these are the various essentials of the will. So there must be a person who makes a will known as testator. So this person must be major, 18 years and above, and must be of sound mind. A person who is not of sound mind cannot make a will. Every will must clearly identify the beneficiaries to whom the property is transferred or bequeathed. If there are no beneficiaries or named, will becomes invalid. It is recommended to appoint a person known as executor. So executor is a legal representative of the testator who implements or executes the will upon the death of the testator. So every will should have a declaration stating that this is a last and final will. The will also should very clearly express the intentions for making a will. Why a person is making a will? What are his intentions? A will is all about distribution of one's assets. So every will should clearly list the assets owned by a person and how these assets are acquired. We also should declare that a person has a competency to make a will. That he is of sound mind, he is a major. Every will should also make a provision for repayment of any debts or loans, especially home loan, car loan, or any other loans. So we should also make a provision for medical expenses and final expenses. In most of the cases, death happens in the hospital, and the hospital bills could be substantial. So there must be provision to pay these hospital bills. So wherever the testator has a minor children, it is recommended to consider of appointing a guardian in the will. So law may allows you a person to appoint a guardian for the minor children. We call testamentary guardian. Again, will is all about transfer of assets of the deceased person. So we must very clearly describe or make a statement in the will, bequeathing or making a statement transferring the assets of the person to the legal heirs. So every will must be signed by the testator. It also must be attested by 2 witnesses in the presence of each other. So these are all the various requirements when a person is said to make a. So with this, now we move to the next instrument we have in estate planning is trust. So many think that estate planning is only about the will, but it is much more than that. Okay. So always the needs of a person need not be that his assets should be transferred to the family members immediately. There are certain cases where we recommend to the client not to execute a will because of various shortcomings of the legal heads or beneficiaries. Okay. So here we talk about the trust. So what is trust? A trust is a relationship where the property is held by one party for the benefit of another party. So there are 3 parties to the trust. One is author of the trust, second one is trustees, and third one is beneficiary. A person who executes the trust or who settles the trust is known as author of the trust. We also call him grantor of the trust or settler of the trust. So how the trust can be settled? By transferring the property to the trust. The purpose of trust is to manage the property and provide the benefits of this property to a certain persons known as beneficiaries. And for the management of property, we appoint a third parties known as trustees. So trustees are those persons on whom you have a trust. So in this case, author transfers the property or assets to the trust. And the trust is managed by the trustees, or trust property is managed by the trustees, and the benefits of the trust property is passed on to the beneficiaries. So beneficiaries here in this case will be family members. So when the beneficiaries are family members, we call it as a private trust or family trust. So eventually, in case of trust, there are setter or author of a trust, there are trustees, and there are beneficiaries. These are the three parties, and there must be a property which is transferred to the trust, and this trust is established by executing a deed which is known as trust deed. Okay, trust will come into effect by executing a trust deed. So where we can recommend the trust, the purpose of the trust. So where a person is not capable of managing his own wealth, the incapacity to manage one's wealth, he can think of having a trust. Today we had a client who they are 80 years and above, husband and wife, no children, they don't have any close relatives. Okay, they have their own concerns about their property, living to the other family members. So they wanted to have a system where it can be managed by the dependent persons, trusted people. In this case, a trust is created. All their assets are transferred to the trust, managed by the trustees, and benefits will go to this couple because they themselves doesn't have a capacity. A single parent with minor child or children. If something happens to single parent also, or single parent also dies, though the property is left behind, child is a class 1 legal heir. Child has a right to inherit, but being a minor, the child does not have a capacity to manage. Then there must be someone in the absence of both the parents to come forward and manage the property of the child. There could be mismanagement also. So better to have a trust. Parents with special child or children. In the absence of parents, who will look out for the well-being and welfare or the property of this special child? A trust will play a role. Financial security for spouse and children. Spouse and children are not capable of managing it. Spouse is not aware about all these financial assets or instruments, how to manage, where to invest, how much to invest. She does not have an aptitude even to learn. So how do you provide that security? Better to have a trust. Financial security for parents who are old age, even though you give them lakhs of rupees, but because of their old age, they are not able to manage it. Or it could be financial security for married daughter. Instead of giving as a gift or whatever you call on the occasion of marriage to the married daughter, which can be misused, where she can be under a lot of coercion. So better to create a trust and transfer this gift money to the trust and make the daughter as a beneficiary and the children as a beneficiary. The trust is also a useful instrument for the preservation of wealth. So instead of transferring all the property where the beneficiaries can sell or transfer the property, can misutilize, you transfer the property to the trust and make provision only the transfer of income to the beneficiaries. The assets are preserved. A trust is also a useful option for the business succession. So these are the various situations where a trust can be a useful option. So finally, we have power of attorney. So power of attorney, many of you would have heard or you would have executed. Attorney means a representative, and you give a power, certain powers to this representative. Okay. So power of attorney is a document by which you appoint a person as your representative, and you give certain powers to him to do certain acts or actions on behalf of you. This power of attorney is a very useful document for the management of one's assets during his life when a person himself is not capable of managing it. So power of attorney can be given to operate the bank accounts, to do the management of real estate assets, or to enter into the agreements and deeds, or to represent in any court or in any case. So wherever person himself is not able to reach, he can authorize another person to represent him. So this power of attorney can be a general power of attorney, where you give wide powers to your attorney to represent you in almost all legal acts, or it could be a special power of attorney, where the authority is given only for a specific purpose, like operating a bank account or a management of real estate property or management of any other investments, or it could be medical power of attorney. So who will take healthcare decisions in the event you yourself is not in a position to take such decisions, and power of attorney to manage financial affairs. So depending upon the need, we also need to consider the need for power of attorney for the management of one's assets and financial affairs during the life of a person when he himself becomes incapacitated. So these are the instruments we have in estate planning. So in this webinar, we discussed it in the first part, we discussed it about what is intestate, what is testament. In the case of intestate, we discussed it that succession laws will apply. These succession laws are Hindu Succession Act, Indian Succession Act, and Muslim Personal Law. We discussed it, the rules of succession for the assets held by Hindu female and Hindu female. Similarly, we discussed it, the inheritance rules for the Indian Succession Act for Indian Christians, which also applies to the couple who belong to different religion. And then Muslim Personal Law. In the second part, we discussed it, what are the options we have to overcome all these complexities of inheritance, so without having any disputes, how we can transfer seamlessly to the family members. The alternative we have is to execute a will, a trust, and also look at power of attorney for the management of one's assets. So all these together, we call it's a estate plan. So with this, I close my session and I'm ready to take any questions you have.
Thank you, Mr. Suresh. That was really informative and very thorough. Now, for some time, we will have some Q&A session with you, sir, and then we will conclude this webinar with some polls. So we have some, we have got some questions in our Q&A box. I request all the participants to please ask their questions in the Q&A box. We will address them all one by one. I also have my sets of questions which I have gathered from some of my clients, so that also I will be asking, sir. But let's just first take the questions from our Q&A box, sir. Regarding the Parsi succession planning, sir, which there was one slide in that. So the questions comes: what about Parsi marriage? Parsi, both husband and wife married under Special Marriage Act, no children. Then what is the law?
So registration under the Special Marriage Act is your choice. But since both are Parsis, a husband and wife both are Parsis, then Parsi succession law will apply. Similarly, a Hindu, both are couple, husband and wife both are Hindus, but for various reasons they have chosen to register their marriage under Special Marriages Act. But even then, since both are Hindus, Hindu succession law will apply. It applies only when the marriage takes place between the people who belong to different religion. I hope I answered that question.
The next question we have is, a single mother with minor kids, what is the best way of estate planning? Creation of a trust or a will?
Generally, I say trust, but it's not that always it is a trust. We need to discuss one-to-one. Different scenarios and situations I need to understand before I give my recommendation. Okay. Now let us say if the child is 6 years old, 3 years old, my recommendation will be different. If the child is 15, 16 years old, though minor, my recommendation will be different. Okay. So it is better to have a personal discussion and then determine it. It also depends upon what kind of assets that are held by the mother or father, single parent.
We have another question from the same participant. Is there any minimum asset amount for creating a trust?
No. Even you can create with even 1,000 rupees, 5,000 rupees, 500 rupees, whatever money you have. The trust can accumulate the funds in the future. Okay. So even as less as 5,000 rupees.
So there is one question which I have got from a recent, very young couple. They know the importance of estate planning. They want to know the psychological this one, that how to start the conversation with their parent to let them do the estate planning or make them do a will creation. So so you might have gone to several clients that how to start the conversation for their parents to talk and start the conversation regarding this one.
Conversation, it's nothing like a standard. It all depends upon the situation around there. When I go there, okay, how do I know the person? How much liberty I can take to start? Okay, Shall I start right away? If you die, this is what happens. No, isn't it? So it is a situation. It is a situation. Yeah, first we of course try to establish our relationship with them, take them into confidence. Then slowly, gently, we have to put a question. Okay, do you think what will happen to your assets? Who you love very much in the family? Have you made any protection for their well-being in the future? Okay, so how do you can make a plan for the financial security for your wife and children, or your wife who's aged? So slowly, we have to take over a period of time.
There is one question from our participants. If the person dies intestate and the wife is left with no document about the property and son keeps the document as he doesn't want to share the rights with other parties like mother and sister, what should be done?
This is where I said 60% of the disputes in courts are inheritance disputes. This is one reason. I think disputes arise, go to the court and try to settle it. That is why we say have a will, estate plan.
There is one more question which I have got from one of the existing clients. How can someone protect their assets from creditors or lawsuits after they are gone, since they are businessmen and they have this query of if they create a will, so how that will be settled after they are gone?
One of the options for the protection of asset is trust. What kind of trust is useful? How it is useful? Again, we have to discuss with the client and then determine how to go ahead. See, whatever information I've given in general. The same thing does not apply to everyone. Right.
Yeah, so there is one more question regarding what is the cost associated with creating a trust approximately?
It depends upon the professional you approach, okay, and what kind of desires or your requirements for creation of trust. Okay, but just to give you a idea, it could be anything around 25 to 30K, approximately.
So can we?
There are people who charge even in lakhs also, but don't ask me that somebody is saying lakh why it is 25K. I just gave you. It all depends upon the professional you approach.
Average approximate cost. Yes. The last question which I asked about the if the person dies intestate with no documents. So again, he has answered. He had an add-on question. Can we approach the court with having no documents? Any suggestion regarding that?
See, unless you prove that the deceased person has owned the assets, so on what basis you file a petition in the court? Yeah, if you have a strong feeling that yes, he owns the asset, he has investments, but the other part is not disclosing it, please go ahead. But you need to be sure before you file a petition.
So one more.
Suppose I am the person holding these assets, and you don't have any documentary proof that that person has left some money or whatever it is with me. So it's very difficult to prove. So when a person makes a will, he will list all these assets. When the will is registered, there is a document available with the sub-registrar's office. Family members and legal heirs can have an access to this. This is one reason why we say execute a will and register it.
So one more last question from my side. So that is add-on to the documents one. So how much time does it require, average time in the whole process to start and complete the creation of will? So what is the approximate time is required in that case?
My experience is that the client or the person will take more time to list all the assets and determine to whom this asset should go than the time I require to draft the document. Right. So I asked this to many clients. They say, "Sir, yesterday also I had met with a client. When I said this is all the information I need, sir, it takes time. Give me 2-3 months time to come back." When none of this information is organized, it's not in one place. That is reason 1 lakh crore plus is lying unclaimed. A person himself who has invested doesn't have a proper document or a list where all he has invested. Okay. Tell me, you just answer yourself. How many families, the members of the family, know that where all the earning member has invested, the family head has invested? My wife may not be knowing where all I have invested. Neither they are interested, and in some cases, wife is not interested to know, or in some cases, husband don't want to share with them. Very few families we see the transparency where husband and wife exchange all the information. Children don't ask. I don't think any parent will share all their investment details with his children. Then that's where unclaimed deposits. Right? Yes, sir.
So that was it. So that's all the questions from our side. So it's a request from our side. If you have any more question, you can approach Mr. Suresh, or you can approach us. We can get in touch. We can get you in touch with Mr. Suresh. Please follow us on the social media platforms. Before going on, we'll just have a small poll for all of you regarding the webinar. So just let me know. Just have the poll. So there is a poll in front of your screen. Please vote into that. One more short poll. Sir, are you able to see the? Okay. So thanks all the participants for joining and being with us for 1 whole hour.